Hello there. Thank you for staying with us and welcome to Face Off on Channels Television. I'm Nelta Egbe. And yes, indeed, the inability of some state governments to pay workers' salaries over several months may have eroded whatever goodwill they might have enjoyed from the people. The crisis assumed a twist when a sitting judge in Osun State, Justice Folahanmi Oloyede, wrote a petition against the governor and called for his probe and possible impeachment. For some stakeholders in the judiciary, no matter the intention of the judge, writing that petition automatically puts her in the arena of politics, which conflicts with the provisions of the Federal Republic of Nigeria's Code for Judicial Officers. I have a copy of that. I'm going to read out some things from there. Now, does the petition of the Osun State judge against our governor raise some ethical questions? Should there be a specific reform that would give judicial officers more breathing space on the social sphere, or would this jeopardize their credibility in court? Now, permit me to look at some parts of the Code of Conduct. The first, Rule 1, says a judicial officer should avoid impropriety and the appearance of impropriety in all his activities. That's Rule 1 of the Code of Conduct for Judicial Officers. Part of Rule number 3 says a judicial officer should regulate his extrajudicial activities to minimize the risk of conflict with his judicial duties. That's Rule number 3. And then still staying with Rule number 3, B sub 2 says, in accordance with the fundamental rights enshrined in the Constitution, a judicial officer is, like other citizens, entitled to freedom of expression, belief, association, and assembly, provided, however, that in exercising such rights, he shall always conduct himself in such a manner as to preserve the dignity of his office. Now, that's from the Code of Conduct for Judicial Officers. Now, there are other cases of judges who have had to go across the lines to do some things that some people have considered unethical. For instance, the story of a judge who had to go to collect an injunction, an ex parte injunction, stopping a bank from publishing his name as a debtor. Is that right? Should that be the case? Or the story of a judge who continues to influence his friend to adjourn a case that has to do with to adjourn a property case just because it was not going to favor him. Is that right? In other words, we're looking at today judicial reforms. Is there hope for more reforms? You can now twist it and say, should there be some specific reforms that, as we asked, that will give the judges more breathing space on the social sphere? I have two lawyers in the House. I'm not the one doing all the talking here. Forgive me. I have two lawyers in the House, and they are going to be doing their talking. Please join me to welcome Mr. Onyekachi Ubani, former chairman of the Lagos chapter of the Nigerian Bar Association and legal practice. Thank you for coming.
Nyata, good evening. How are you today?
I'm very well, thank you. We also have Mr. Nso Dio, a legal practitioner as well. Thank you for coming.
You're welcome.
I hope I got that well. All right, gentlemen, the question we're asking is, the Nigerian judiciary, any hope for more reforms?
You want to start with me?
No, just stick to your
my own position. Yes, there is always room for improvement. But I tell you, an efficient judicial system is very vital to economic development and national development. It's very important for national development.
Thank you. Taking more than 10 seconds.
Well, I don't think we need any reforms. The instruments we have at present are sufficient to take care of these situations.
Okay. We'll take a moment and come back to continue this conversation. Please know that you can be a part of this conversation via our Twitter or our emails. Tweet at FaceUpToday or at NelTagbe, or send your mails to faceup@channelstv.com. Please don't go away. We'll be back shortly.
I love television. I also facilitate conversations between people and companies. I have to research my subjects. My IT guru said to me, we have to switch you to a Etisalat. I said, why? He said, for roaming, for sense. I haven't regretted it for a second. I get into a new country, automatically I'm switched on. And you know the best part? I don't have to pay for all the incoming calls. There's a young lady that I recently heard about. That is the kind of person I'll fly to go talk with wherever it is she is in the world. My former network, I was with them from inception. I switched because I found a better partner.
Switch to quality today. Etisalat, now you're talking.
Welcome back. We're asking the question today, Nigeria's judiciary, any hope for more reforms? I have two lawyers in the House. One says there's no need for more reforms. The other says there's need for constant improvement. But let's get to them and let them tell us why they have taken the positions they have taken. So since you are the one that's saying there's need for constant improvement, ask the first question.
My brother, you said that there is no room for further improvement. You and I know that.
No, I didn't talk of improvement.
Oh, well, for reforms.
Yes.
Reforms, another name for it is improvement. There is this issue of congestion of courts. We have the issue of inadequate or lack of basic infrastructure within the judiciary. We have this same issue of long delays in trials and administration of justice. We have this issue of even corruption. You know, in the judiciary, alleged corruption, and I have justices of the Supreme Court that have confirmed that. Will it be right for you to say that there is no room for reforms in the judicial system?
There are sufficient provisions which we have not activated them as it is now. For instance, when you talk of delay of cases in courts, the rules of the various high courts, in fact, the rules provide that a case shall be heard from day to day. Now, it is within the power of a judge hearing a case to say, look, Mr. Obani, I'm not going to give you an adjournment. Come back tomorrow, come back next tomorrow, give 4 consecutive days. If we apply these rules as they are now, then we are going to get results.
The question that I want to weigh in on that one, is there a limit to the amount of adjournment a judge can get?
There is even a limit. There is even a limit in some high court rules that you cannot take up. I can remember very well the Delta State High Court rules. There's a limit to 5 adjournments. I can also remember very well that in the High Court of Lagos State rules, the case should be heard from day to day. Now, it is within the power of the judge to adjourn the case from day to day to day until he finishes the case.
But since that is not the situation,
now
you are talking about reforms. That is not the situation. You have the rules that, according to you, have made provisions for this, and the judges now are not following those rules, and we're still having delays. Don't you think that there is still room and further improvement, the reforms now, on the issue of checks and balances of the judges? Because when you talk about reforms, it does not, stop at the issue of making the rules and regulation. If you don't also, rev up your administrative checks and balances on the personnel that carry out the rules and regulation, can you say you have a complete reform in that particular sector?
Well, the point which I'm making is that if we apply these things, fine. If you talk of improvement, we always pray and wish for improvement. But let us exhaust what we have. Now, if you are saying, oh, gentlemen, this is the situation, why are you not following it? Let us follow it this way and see whether the courts will still be congested. If they are still congested after we have applied what we have on ground now, then you cannot be talking of reforms at that stage. But at present, we can't leave what we have not exhausted and then go on talking of.
My understanding of reform is maybe a bit different from yours because it's a holistic thing. In fact, there is a sitting that took place in South Africa for a 4-year plan for their judiciary. Yes. And of course, South African judiciary today is far better than most judiciaries in Africa. The same thing with Kenya. They sat down and looked at every area of improvement and reforms, and they went about, carrying it out. And if you go to South Africa today, that's why you have a quicker dispensation of justice. Because if you make the rules, you don't even follow up with issue of monitoring, checks and balances of the personnel. You cannot say that reform is complete, because a human being can be a cog in the wheel of progress. Now look at a state like Lagos. There have always been an improvement on the rules of procedure. Rules, of procedure in civil. The civil rules. Now they started with, we had the rule of 2004. Now 2011, they made another rule, which was an improvement on the 2004 over the 4 rule.
But don't get,
because according to them,
like you're missing what he's saying.
No.
He's saying that there has to be a working of what we have before you say you want to reform it.
No,
and he's of the opinion, from what I gleaned from his conversation so far, is that we're not even working what we have. There's not enough. Is that what you're saying?
Yes, yes.
Okay, let me ask you a question before. The story of the reports out there of a judge who is owing a bank, and with the directive from the CBN now to publish bank debtors' names, he goes and collects an ex parte injunction to stop the bank from publishing his name.
Yes.
Is that right? Seeing that he has not even been servicing his loan, is there something to check that? Are there laws that are supposed to check that judge from doing what he did?
Yes. Now, the rights of every individual are limited. There is what we call the office theory. So your right has a liability or a duty. If you are holding your right in one hand, you have your right to drive on the way also gives you a duty not to hit other people. Your right to a banker-customer relationship information to be kept places a duty on you to maintain the contractual relationship which you have with the bank, that to service the loan. Now, if a judge has taken the loan, he has placed himself in the same position as any citizen, and these rules should also apply on him. Now, if he approaches a court for an injunction, it is a different ballgame altogether. On what basis is the judge giving the injunction? On what basis? Fine, he might be entitled to an injunction, but was he entitled to an injunction in this case? So these are the areas. There is no reform that is needed as far as I'm concerned, because whether he was entitled to injunction or not is a different thing.
The fact that he wasn't even servicing the loan has seemed to have contravened Rule 1 that says the judicial officer should avoid impropriety and the appearance of impropriety in all his activities.
Exactly. The office of a judge is very onerous.
Nyota, it doesn't lie in the mouth of probably a journalist, to sit down and probably
that's why you're here.
Yes, fine, and condemn the judge. And that's why he has gone to court actually to seek what you call legal redress. Now, as to what manner of injunction, could it be interlocutory or interim injunction, or was it given ex parte? Now, the urgency of the matter, can determine the court giving an interim injunction, restraining the bank from publishing, and then putting the bank now on notice to come, and argue the interlocutory application. That is there. Now, he may have a reason for going to court. He may have a reason and say, I've been servicing this loan, but the records were not proper. He may also have the reason like, look, the amount of money you are charging me on interest is something that is unreasonable. We did not agree on that. So there may be a reason why he has gone to court. As to whether he has the right to go to court, or a judge has a right, he's an individual, he's a citizen of the Federal Republic of Nigeria, so nothing stopping him from going to court.
Just like the judge in Osun that wrote the petition has a right too.
Yeah, a judge that wrote a petition against the governor, it has never happened before, but this is the first time. But there must be a first instance. There must be a first situation. It has never happened, as I said earlier, but she's a citizen of the Federal Republic of Nigeria. Yes. And she feels that there is a misgovernance going on in her state, and that particular misgovernance is affecting her salary, is affecting her relations who come, begging for her to augment their income, their expenses. And she has a right to